Hey everyone, it's John and welcome back to another eye-opening episode on probate. Today, I'm going to discuss what you can do to avoid going into probate court. As we know, probate sucks and takes a lot of your time and energy. Losing a loved one during a devastating time for a family can be heartbreaking and create unwanted conflicts. But for our attention today, there are 9 ways to avoid all that drama. These are the exceptions to having to deal with probate court. As a probate and trust specialist designated by the California Association of Realtors, I want to bring you this topic on probate exceptions to not only help you avoid the probate process, but also to get you through these difficult times with the confidence of knowing that it will all work out for the greater good. Hang in there and let's get through this together. And before I get into all the fun stuff about probate exceptions, this week in Los Angeles, the rapper Magoo, Timberland's ex-partner, died at age 50. Ex-NFL receiver Sean Dawkins died at age 52, and the Black Godfather of music died at 92. The reason I address this news about these people's deaths is because we don't know if their property is vested in a trust. If they're not, there may be possibilities going through the probate process. Some of these exceptions could apply to any one of them or to you, but doing what I do reduces your chances of going to probate. Go to the gym, eat healthy, and go hiking. I promise you that you will live forever and you don't have to deal with it. If only that statement were true, we would be all vampires like the Lost Boys. And now let's focus on today's sponsor. It's very valuable to have them on here and I'm excited to share it with you. I welcome you to the like button. I would appreciate you clicking on it. I ask you this because I spent some time researching and developing this content for you. Not to mention that I put this whole thing together without hiring anyone. I do it all by myself and it's not much to ask, but it means a lot to me because I'm the true game changer. In addition, you can subscribe to my channel. Now, let's get back into it like it's nobody's business. All right, friends, on a serious note, let's get down to business. Imagine this. You've worked your tail off to create a comfortable life and a solid financial foundation for your loved ones. But what I mean is, if you're not careful, the probate process can turn your legacy dreams into a nightmare. But fuss not. Today, I'll uncover these golden tickets to help you dodge probate like a pro. But what if you inherit the property and need to sell it? Does it need probate? The answer to this question will depend on how the property was held in the past. Once the grant deed is pulled from title, it would be evident whether the property is vested in a trust under the name of only the decedent, in joint tenancy, as community property, or as community property with the right of survivorship, a limited liability company, a corporation, or a revocable transfer on death. Having that knowledge can determine what exceptions may be in your favor. If you're wondering how to vest your title in your property, it's always a good idea to speak with an attorney and a certified public accountant first. It's also important to find out if there are benefits or drawbacks associated with selling the property. The first and most common way to avoid probate is to obtain a living trust. If it is obtained, probate isn't needed. The reason behind it is because the living trust owns the property, not the decedent. As a realtor, I would first ask for a copy of the trust document to identify the successor trustee. This individual has the legal authority to hire the realtor and sign the listing agreement without court intervention. The successor trustee is the person that accepts the offers and signs documents necessary to close escrow. Next up, we've got joint tenancy. This fancy word is not as popular as it used to be. In fact, it's so unpopular that even its own parents don't want to be associated with it.
Nope.
However, in legal terms, it means that 2 or more people are vested in the property. If the property is vested in this manner, the main question arises whether all joint tenants have died. Probate is only necessary if all joint tenants have died. Let me demonstrate this with an example. Imagine that mom and dad vested their home as joint tenants and dad died first. In this case, probate is not necessary. Instead, an affidavit of death of joint tenants would be recorded for dad with the county recorder, along with a death certificate. Later, when mom dies, probate is necessary. In California, we have community property. I'm sure you've heard of this or have some sort of knowledge of it, but let me refresh you if need be. Let's say if mom and dad vested their home as community property, title passes to the surviving spouse unless the deceased spouse left a will. In theory, mom and dad each own half of the house, 50-50. Thus, mom could will her half to her favorite charity or to anybody she wishes. If this were true, mom's estate would be valued over $184,500 after April 1st, 2022. A probate would most likely be required. Later, I'll explain why I mentioned $184,500. But for community property, if the house is vested in this way, what if the surviving spouse wants to sell the house? What happens then? In practice, the title company asks the children to sign off on the escrow without probate court involvement. If the deceased spouse has not put in place an estate plan, the surviving spouse may have to appear in court and request a court order to receive the deceased spouse's half of the community property if no estate plan has been put in place. But some title companies will allow the surviving spouse to close without a court order if he or she signs the Affidavit of Surviving Spouse, succeeding to community property. The next one is the I love you way of holding title, called community property with right of survivorship. Just like a married couple, you and your title will never let go of each other, even in death. This exception allows spouses to transfer community property directly to the surviving spouse. No probate required. Let me explain. The only difference is that property passes on death to the survivor without any potential problems presented with community property. This means that if mom and dad have their home vested in this manner, upon death of the first spouse, the surviving spouse automatically gets 100% right to the house, not 50%. In the event of the death of the last surviving spouse, as probate is required because neither husband nor wife can will their half away. Beginning July 1st, 2001, husband and wife can vest their home in this form. According to EY on IRC Section Code 1014, property owned as community property with a right of survivorship retains all the features of community property. This includes receipt of a new cost basis on death for both halves. For example, whoever inherits the property doesn't have to pay tax on capital gain. The day that the house is sold after the death of both mom and dad could get a step up in basis of the value of their property. So 40 years ago, the house cost $400,000 and the house is commissioned to sell at $3 million market value. The cost basis is raised to the market value of $3 million and no capital gain tax is due. This is the most attractive part about having community property with a right of survivorship. This next exception, we have revocable transfer on death deeds. These deeds are so revocable, they might just revoke themselves. These gems let you transfer your real property automatically to the beneficiaries upon your passing, waving goodbye to probate complications. This is a fairly new way of transferring real property without probate court intervention or trust. Let me explain. On September 21st, 2015, this method was introduced and later updated in 2021 that a person may transfer certain real property on death by revocable transfer on death deed, also known as RTOD. The homeowner would simply add the beneficiary to the RTOD, and when the homeowner passes away, the beneficiary would automatically be entitled to the house without any probate proceedings. Here's what I'm talking about. As of January 1st, 2022, an RTOD can only be used for a residence. This is defined as a property with 1 to 4 residential dwelling units, a condominium unit, or an agricultural real estate of 40 acres or less that is improved with a single family residence. This law also includes that if an RTOD has multiple beneficiaries, a distribution must be made in equal shares. The RTOD must be witnessed by 2 impartial witnesses, be notarized, and recorded no later than 60 days from the date of notarization. Upon the homeowner's death, all intestate heirs must be notified of the RTOD. Hold on to your seats because here comes the spousal petition. When a person dies, whether with or without a will, leaving real property that passes to the surviving spouse or registered domestic partner, the surviving spouse or partner may file a spousal property petition to receive the real property without probate. Let me explain how this works. If the house is community property or if a will was left behind by the deceased spouse, giving the house to the surviving spouse, then a spousal petition would succeed. On average, probate takes about a year to close its case. However, by completing the spousal petition form, it would only take about 3 to 4 months depending on the court schedule. Here are some key takeaways for using the fast-track spousal property petition. 1. The house must be acquired during the marriage. The legal presumption in California is that property acquired during the marriage is community property. Thus, the surviving spouse would already own 50% of the house, and the spousal petition would simply petition to transfer the other 50% of the deceased spouse's interest to the surviving spouse. 2. The surviving spouse must use this procedure when one spouse passes away and the house is community property. 3. The names and addresses of all heirs must be provided on the petition to receive court notice. And 4. Once approved, the probate judge will sign the order. This certified order needs to be provided to the escrow to close escrow transaction. These were the key takeaways from the spousal petition. Now, let's turn our focus to the next exception. I find this one to be one of the most interesting, called the Hegstad Petition. Hegstad was named after a 1993 case, Estate of Hegstad. Often when the house is deeded to the trust owns the house. In some cases, the homeowner may want to refinance the house, and some lenders may require the house to be deeded back to the homeowner before refinancing. Here's the kicker. The problem arises when the homeowner dies and the house was never transferred back to the trust. Now, would probate be necessary? This all depends on the facts and circumstances. Let's explore some of them. In most cases, an attorney prepares a trust in a nice fat binder. If there's a trust with a Schedule A that lists the subject property and there's a pour-over will that states that all the property shall be poured to the trust, then almost always it will succeed. No probate is necessary. However, what if there is no Schedule A and the house is nowhere mentioned in the trust and there is no pour-over will? Now we open up a whole can of worms here. In this case, we can now rely on the landmark case called, no matter how you want to say it, not interested in trying to read that, but that's a real case. This stands for the proposition that a general statement in the trust instrument that the grantor assigns all the grantor's interest in all real and personal property is sufficient. You'll be lucky if some probate judge approves the Hegstad petition, even when there's no pour-over will. Regardless, a Hegstad petition will have a court date, and all heirs and trust beneficiaries will be notified of the court date. The probate judge will sign an order declaring the house a trust asset, and escrow will need a certified copy of the order to close. It usually takes up to 4 months to complete this process. As mentioned earlier, let's discuss some property values with special exemptions. Effective as of April 1st, 2022, if the aggregate value of the decedent's property exceeds $184,500, a probate is necessary. However, if it's worth less, not worthless, worth less than that amount, it's not necessary for a probate. Now, the question is, what applies to properties less than $184,500. An affidavit regarding real property of small value may be used in this situation. If the decedent owns raw land or a fractional interest in real property and the value on the date of death is less than $61,500 and at least 6 months have elapsed since the date of death of the decedent as shown in the certified copy of the decedent's death certificate, one may use this procedure to avoid probate. In this case, one must hire a probate referee to appraise the value of the subject property. He must sign the inventory and appraisal form under penalty and perjury stating the value on the form. This procedure cannot be used if there is already a probate proceeding in a decedent's estate. Additionally, this affidavit requires a declaration that all funeral expenses for the last illness and all known unsecured debts of the decedent have been paid. This procedure doesn't require a court hearing date, but all the heirs need to sign off on it. This usually takes up to 2 months. The procedure typically is used in situations where the decedent owns raw land under his or her name. You can avoid probate for real property worth $61,500 to $184,500 by filing a petition to determine succession to real property. This form can only be used if at least 40 days have elapsed since the date of the decedent's death and there is no ongoing probate in California of the decedent's estate. Also, to avoid probate, the probate referee needs to value the real property between $61,500 and $184,500. In addition to this procedure, will require a court hearing date to be approved and signed off by the probate judge. Usually takes up to 2 to 4 months to complete. Then the court will ask all the heirs to be given notice. This means collecting all the names and addresses of all the heirs on the petition to determine succession to real property form. So there you have it, my friends. These were all 9 probate exemptions. They're like the secret sauce to making sure your legacy is passed down smoothly. But don't stop here. Hit that like and subscribe button and stay in the loop for more probate tips tailored just for you. Until next time, this is John Atamian from LA's Real Estate Talk, reminding you that your legacy is as unique as you are. Take care and stay tuned for more.